And I'll now hand over to Professor Thomale for his concluding comments. Thank you.
Thank you. So I hope I mean, it's been quite a day, so I promise I won't keep everybody too long, but I still wanted to make good use of the, as I perceive it, French tradition of a synthèse at the end of such a congress. And I was was really struck by the breadth and the richness of contributions we've heard, notably because they went way beyond what you typically have in comparative legal conferences, as in simple reports that sort of build width but not height in argument, if you take my meaning. So to not wanting to, not being, presumptuous enough to be wanting to summarize what we've said today, but I would still offer a couple of synthetic reflections. So the first, I think, is on a conceptual level, and this is most important to those sort of non-believing jurisdictions like the Austrian, the German, and to a certain extent the US jurisdictions in this. I think it was very helpful to be exposed to the sheer possibility to identify what we oftentimes take as a necessity to be a mere convention. And the conventionality of not allowing legal persons to act as directors is directly proven by what I call comparative evidence. Okay, so it's just the fact that there's a whole myriad of legal orders that make a living with this item, with this institution. So on a conceptual level, we're done with believing, no, this is God's spell, what we find in our corporate statute or whatever. But still, I'm still struck by what Johannes Flume said in his contribution when the first explanation he offered was the Führer principle. You remember, he said, well, the leader of a company must be a, some human being. And I think there's more to it than appearance tells, because there is something, as we've delved into the subject, we found these, for example, these interlocking endless series of intertwined legal persons. And what we see is that our mental capacity to actually to stretch, to encompass these ever the more complex constructions, which, Eva, as you point out, seems even to be the norm in the UK, that there is something sobering in an intellectual way to have at least something natural in this entire game, something that is sort of that sticks with basic sort of perception. So I think there's behind this Führer principle, what Johannes offered, there's just a general reticence to over construct, to exaggerate the noumenal power that the law has. And this is what Erich said in his talk, that, and this is why the reference to Kelsen was, even though I might have alleged it to you, was well received, because the entire operation of law is noumenal in nature, so that everything is fictitious of sorts. About I usually, when I have classes, I ask if anybody has ever seen a contract, and whoever raises his hand is suffering, because if ever, they've seen a copy of a contract, but the contract is invisible. Okay, it's a noumenal entity. So there's something sobering about this, and this that's the first point about it. So I think we can stick to the fact that there's nothing necessary about not allowing legal persons to be directors. At the same time, we found that most legal orders, and this is something, a recurring theme of all the speakers, most legal orders make these choices unconsciously. It's not, most of the times, Paula, I mean, we cannot point to any legislative decision, any actual black letter consideration that guided the way in either allowing, because Eva, you said basically that's the contractarian paradigm of UK law. Anything goes if it's not forbidden. So, and it goes the other way around, okay? If it's in other legal orders, it's just that default, whether your default is prohibition or whether your default is permission, that seems to decide this rather intricate issue. So because of all these path dependencies, I think you were well advised to look at how these legal orders disintegrate, as Mock said, you know. So even legal orders that, due to their own path dependency, generally do not subscribe to allowing corporate entities or legal persons as directors, even those legal orders seem to be nibbling away at this general decision, because these changes at the moment, unless you have actual reform, like in Switzerland or in other places, they go sort of unconsciously. Okay, all of a sudden this liquidator sneaks in, who can be a legal person, and you never actually square, you know, in this gigantic system, in this clockwork, you don't always square developments in one part with the other. So it's a possibility, but we have to resist this iconoclastical sort of urge to draw the conclusion that just because it's not a necessity, that it should be a possibility. You know, as I like to say, sometimes locked cabinets are still empty. Okay, so just the fact that they're locked, just the fact that some path dependencies kept us from looking at this in a more sort of broad way, that doesn't mean that it's actually a good idea to introduce it, as I think Eva also brought out. So that takes me to the second level of discussion we had, and that's the policy level. What do we actually want? What is good policy here? And we've seen the breadth of solutions. I mean, we've had the sort of the diehard no legal person legal orders, like US, Germany, Austria. A lot of 50 shades of in-between permissive systems, and then straight out liberalization, notably in Liechtenstein. And it looked to me as if Turkey were headed that way as well, Kerem. Now, as these, any of these solutions are also houses divided against themselves, as you remember, because they sometimes carry these contradictions. Okay, so it's never absolutely clear cut that you can assign one exact solution to one legal order. But as we move deeper and look at, okay, so this is what the world has to offer at the moment, which one does our policy preference lie with? Eva said, yeah, we just have to do a cost-benefit analysis. And this is, you know, if I can quote Goethe, und das ist ein großes Wort, gelassen ausgesprochen. Yeah? So yeah, just do a cost-benefit analysis, and whichever succeeds, that's what we do. The problem is that this is incredibly difficult to do. But I think we've at least started to develop first ideas, first parameters of what kind of discussion needs to be had. I think the first point is the caveat that Todd made in his contribution, namely that there is a certain institutional interdependence of all of this. And some of them have been highlighted to us. First, the transformation from Todd's idea from a board system to two-tiered system that came up ever so often, that this doesn't go that easily. It needs adjustment in order to work in other legal systems that work with two-tiered systems. Then the question, the dispute between Erich and Todd, do we actually have a functioning management market? That's actually nothing, it's not a negligible side effect. But if we do have that anyway, yeah, then of course the question has to be answered in a different way than if we don't. And that can also change. For example, I would hold that Austria has an almost non-existent market for management for reasons I cannot get into. Okay, so that changes the entire setup. Okay, but then also we found institutional interdependencies with the question of de facto organs. Okay, many speakers brought up the question, okay, so if we do allow legal persons as directors, how do we deal with de facto and shadow settings? Okay, that's something else that you cannot discuss in isolation. So whenever you make a real pitch on do we want to allow legal persons as directors, then that has to go with a couple of positions adjacent to that, like what's my stand on de facto directors and shadow directors. And there's plenty of other questions to be solved. I don't know if you've noticed, but the organizational vision that Todd offered to us at the outset was one of BSP, of these centralized, like a McKinsey for boards, and a McKinsey for boards that would be even closer incorporated into the company than just McKinsey, because McKinsey is just it's just contracting a company, but it would be even closer into the woven into the structure of the company. I don't think that the legal orders that we've heard brought out that setting. What we rather found were group structures organized by using legal persons as directors. So we found that, and then Eva, we also found straight out fraud. so I think Eva comes, Eva lands somewhere. Well, there isn't actually a good use case for this. You know, it is neither BSP by Todd nor group organization. Other questions that came up that needs answering is the entire liability question. Remember that was in the center of interest, especially to France, also to Italy. The idea that we want to avoid the moral hazard that can result from having legal persons as directors and so on and so forth. We had the transparency question, where Eva, I think, made an interesting point about this reform proposal to work with registration requirements, because that could be very cheap ways of achieving transparency. We've had ideas of antitrust, and especially when I listened to Luz and also to Paula, I get the idea that we could learn. I mean, we're scratching the surface of questions that need answering once you open that kind of worms with legal persons as directors. So where does that leave us? I mean, there are plenty of other points, but I don't want to keep you too long. The last point after the conceptual level and the policy level to me is the methodological level. So where do we go from here? And more importantly, how? And my academic pitch on this is what we've done in this conference. It is to work conceptually and comparatively. That is, a standalone comparison, in my view, doesn't lead anywhere, just sort of reports legal facts. That really doesn't yield anything. What you need is a conceptual angle that conducts, or that drives and guides the comparison. This is what we've been trying to do today. With the first couple of speakers, we try to get a conceptual grasp of what are we dealing with, what is the actual problem, and then try to see the solutions offered by certain jurisdictions in the light of that very problem we've identified. I think that is the way to go. I call that economic comparative law. So basically to use notably economic analysis to guide the comparative endeavor. Having said that, whether that leads to better law is still to unravel. I was really taken by Pierre-Henri, what you said when you said maybe Austria is just a little bit too big. You know, it's big enough to be lazy, basically. Yeah. So basically, it's not too big to fail, but too big to succeed. Actually, in the competition for regulatory solutions, just as something to think about, what we've done today, in my view, before you have law reform, should be institutional standard procedure before you even touch law reform. Imagine, especially those from Austria, from Germany. I mean, the way you looked at this problem before you came here today, and the way the nuanced vision you have of it right now. I wish at some point in time our legislators could have that economically, conceptually, policy, and comparatively informed vision. I think that might lead to better laws in the long run. I think what we can do, we have done. All I've left is to thank you all, notably to all the speakers, to the chairs of our sessions, to my team, which did a splendid job in organizing all of this.